the discussion along the topic which they have been given, and thereafter we'll go to the next session before we combine the plenary, so that we can leave here in good time. So I think Patricia, you'll start, then Felicia, and then Matthew Mutiso, along the topic which we've been given, advancing access to justice for all, the rights of the vulnerable groups. So we'll give each and every one of you 10 minutes. And if you go past 10 minutes, I am the only one who is allowed to tell you to stop. But I don't want to tell you to stop, because I can't tell ladies to stop. It's only Mutiso I can tell to stop. So take your 10 minutes, and then we can move from there. Thank you. Patricia had a presentation. Our technical team, has it been put up? Our technical team, Patricia has a presentation which she wants to, I don't know how we'll manage it, because Duncan has taken the podium. Will you manage from there? Okay, thank you, Patricia. I'll sit next to Kimondo as I watch you people.
Thank you. Thank you very much, Judge. This panel was dealing with vulnerable groups, and my presentation focuses on children, and it is basically a review of how, as the High Court, we have applied the best interests of the child principle to enhance access to justice for children. And this principle of best interests is well articulated in those instruments that I have set out there. And each of them actually pronounce that the best interests of the child must be the paramount consideration of the law. So one instance where the court has applied this principle to enhance access of justice, enhance access to justice is where there has been a lacuna in the law. We know that whereas it is clear the procedure to follow when handling children in conflict in the law, the law is silent on what happens when the child transits into adulthood in the course of the trial. So in those two decisions that I have posted there, in both instances, the court cited okay, those who are using the flash, one of the panelists has she's sensitive to the flash camera, so it's troubling to her. Kindly do not flash. That's not on my slides. So, yes, so those two decisions, in revising the decisions, the court said, notwithstanding that there is a lacuna in the law, having regard to the best interests of the child, in both instances, they did make a decision. I believe in both instances, the children had committed grave offenses, and the court did mete out custodial sentences to them as they were adults. The other instance where courts have applied the best interests to enhance access to justice is where we are dealing with the troublesome topic of consensual sexual acts between minors. Courts have increasingly said there needs to be a different approach in what has come to be referred to as the Romeo and Juliet relationship. So notwithstanding that the court has held that the criminalization of consensual acts between minors is not unconstitutional, courts have nonetheless, whilst promoting diversion, still held that the sentence should be one that reflects the social realities. And both those decisions did speak to that and say we were actually populating our jails with people who need not be there. The next decision, the next batch, is where courts have applied that principle again to ensure that there is non-discrimination towards children based on their birth, so whether or not their parents were married. So this is the case where, for some reason, the Registrar of Births the Act said if parents were not married, the father would not be reflected on the birth certificate, and other provisions that discriminated against children born out of wedlock. Again, the courts made reference to the best interests of the child. So there was the registration of births, there was the Succession Act, etc. So a number of statutes. The next one is where the issue was ensuring that a child has access to parental care or their right to identity. And what was being considered here was the parent's right to privacy, where a parent felt being compelled to undertake, well, not a parent, an assumed parent felt that being compelled to undertake a DNA test was an infringement to their right of privacy. Applying the best interest of the child principle, the court held that the child's right to parental care and identity would override that right of that adult because there was a prima facie case. Then that principle has also been applied to safeguard equal parental rights to a child. We will know historically it was almost cast in iron, the tender years doctrine, but in recent decisions, beginning with SMM versus A&K, the court emphasized that the tender years principle is not an inflexible rule of law, and it would yield to the best interests of the child principle. And in that particular instance, we saw a father having the right to custody of children of tender years. So I'd like to say that in conclusion, what we can observe is that by applying the best interests of the rights, best interests of the child principle, we've been able to enhance access to justice for children. Thank you very much.
Thank you, Justice Nyaundi. Sorry, I'm Felicia Mburu from the Kenya National Commission on Human Rights, and sorry, I'm waiting for a picture to come up so that I can proceed. So when we talk about vulnerable, my topic, it's quite interesting. What I've always wanted to tell the judiciary is that we need to see things differently. How we work, how we operate. It's all about reframing the conversation when we talk about vulnerability, because one of the founding principles of vulnerability is legal capacity. If people have power to make decisions over their lives, to make decisions over, to make particular decisions over their life, over their choices, over who they live with, then we end up addressing the question of vulnerability. So as the Commission, one of the things we really focus on is we try not to limit ourselves to boxes of disability, gender, children, but we look at the question of how do the intersectionality of these things make me a vulnerable person? Oh, finally. And if we could all look up to that picture, it's, first of all, welcome to the holidays, but it's very intentional. Again, it's about 12 reasons why Santa is actually autistic. And each of those are very intentional to show you what you don't see when you're looking at vulnerability. So the first thing they say is that he lines up and names his reindeers over and over again. That's a very typical, repetitive behavior is one of the signs and symptoms of autism. He wears the same clothes every day. People on the autism spectrum and neurodivergence, including some types of cerebral palsy, Down syndrome. Also, we have tactile sensitivities, and therefore certain types of clothes will make our situation worse or better. My favorite one is that he has a very limited diet of cookies and milk. Again, people on the neurodivergent spectrum tend to have a limited diet because of gut issues that come with that. But when we think about people on the spectrum, we have a different idea of how it presents itself, commonly known as mwenda wazimu. Half of us, when they come to court, like one of the things I raised when I walked in here was that I questioned, where's the interpreter? Because I'm a little bit hard of hearing at the same time, and there was no interpreter. So I was like, okay, how then do you expect me to participate as a panelist? And I don't know, I can barely hear what is really going on in the meeting. And then, anyway, that was one of the things. The idea why I was particularly sent to have this conversation is to challenge everyone to start seeing things differently. And all of this comes back down to the question of legal capacity. One of the things that I love talking about migrants, when you look at migrants and when they move, they automatically become a person with disability. Article 27 of the, I will be using person with disability, but please keep in mind I'm talking about vulnerable groups throughout. It's just disability tends to be the most marginalized of the marginalized vulnerable groups. So when you look at migrants moving from one place to another, for whatever reason, whether it's economic or they're running for safety and things like that, you find that they all have one thing in common. It's a language barrier involved. It's confusion involved. It's limited diet involved. Everything has to be black and white, and there's limited access to information. So then the question becomes, how then do we deal with migrants? Because at this point particularly, they're falling under Article 27 of the Constitution of Kenya. There's some form of discrimination. Just because you've presented yourself in your body and space the way you are, you will form a form of discrimination, and therefore your rights end up being violated. And it all comes down to the question of legal capacity. A good example is my passport. If I walk around without my passport in Saudi Arabia, I have no rights. Anything can happen to me at that point, and my employer can do whatever they want, and they have no redress proceedings that I can go with. However, if I have my passport, if at any point I decide I'm done with this employment, I can walk out. I can leave that country and go back to my home country, and nothing will happen to me. Legal capacity, the fact that I have an identity, gives me my protection. And that becomes the foundation for human rights. Bringing it back to disability, one of the things that I was hoping to project, but it might not, the Article 260 of the Constitution of Kenya highlights disability. This is the definition that includes any physical, sensory, mental, we tend to leave that out, mental, psychological, or other impairment, condition, or illness. Under the United Nations Convention on the Rights of Persons with Disability, that is what we call the medical model. What you're saying is, my disability is the problem. So it's my problem, sort it out. But what does the CRPD tell us? We need to switch it, together with the African Protocol on the Rights of Persons with Disabilities. We need to switch this to a social model of disability. The social model of disability is the environment and the society I live in is the problem. They're the ones who make me disabled. If all of us can accept Santa with all his peculiarities and see him as a nice person, as a human being, and the perfect reason for the season, despite the fact that he's autistic, why then can't we accept our neighbors, our society of persons with disabilities, and just change to suit that situation? Because the idea is, if you have a disability, you don't have legal capacity. But if you give me back my legal capacity, I'm good to go. That same Article 260 of the Constitution talks about marginalized groups. Another area, how the vulnerability comes into this. Marginalized group, community is the statement that is used in the Constitution. A group of people who, because of laws or practices, before, on, or after the effective date, are disadvantaged by discrimination in one or more of the areas identified under Article 27. So not only are persons with disabilities identified under the disability category, they're also a marginalized group. And this is why I jump into the deaf community and why I love them. The deaf community is a people who have a particular language and a particular culture. Ideally, if we talk to a deaf person in their language, they're no longer disabled. If we talk to a refugee in their language, they're no longer disabled. They're able to participate in court processes by giving them the reasonable and procedural accommodations that they require to go through the court process. However, we go to court and there's a refugee there. One of the hardest languages I've had to deal with was someone who was speaking the Tuareg language. The Tuareg language is completely different, no relational language, and therefore you have to get an actual Tuareg to come to court to interpret it. And he kept asking for accommodations. In the absence of a language interpreter, in this day and age of technology, we find ourselves not able to get internet connection in Niger for someone who can speak to this gentleman in his Tuareg language. But the good thing also was that he's deaf. The deaf is a unifying language, so I was able to communicate with him in sign language, though he was technically speaking French Sign Language, but we're able to communicate. So when we remove our own personal biases and see the Constitution for what it is saying, Article 260 of the Constitution, that the marginalization is not the person. The problem is us, the society, and the environment. By denying someone their legal capacity, we cause the disability, we cause the marginalization. But if we give them their legal capacity in a language and environment and remove the societal barriers around that, we're able to bridge this divide of vulnerability and give people their human rights and their dignity back. Thank you.
Thank you. I'll follow the protocols that have been set before me. All protocols observed, that is me. I work for a coalition for mental health organizations. One of the projects that we are currently working on is volume. Okay, thank you. One of the projects that we are currently working on is a petition in the Constitutional Court to decriminalize attempted suicide. That is petition number 045 of 2022. Professor earlier on spoke about the medical model of mental health, which we've all, I believe we are familiar with. We've heard of issues of chemical imbalances, genetics, and so on. These are some of the issues that bring persons with psychosocial and intellectual disabilities to the courts. But according to us, the court can only do so little about that. Felicia has spoken briefly about the social model, and that's what it means, basically. And then there's a human rights model. It goes ahead to speak about certain specific rights of persons with psychosocial and intellectual disabilities. The CRPD, of course, globalized both concepts. And we know that mental health determinants are based on either social determinants, environmental determinants, or biological determinants. And of course, we have the African Disability Protocol, which complements the CRPD. Next slide. This is a brief picture of what is currently our state of mental health. I won't go so much into it, but maybe a look at the community aspect of care. In high-income countries, access to community care is at least 1 out of 7 persons can access care. But in our context, there is no care for mental health services. And as I proceed with my presentation, I'll show you how prison populations are related to mental health issues from a social determinant perspective. Next one. There was a study that was done in 1986 by the Center for Disease Control in the US, and it brought out these two, we call them realm of ACEs. These are adverse childhood experiences. It says that if you're hit with these adversities between conception and at least the ages of 21, they affect your resilience and ability to adapt, and it creates an affinity towards crime. If you can, you just maternal depression, some of them we are acquainted with, and also maybe just to give a disclaimer, some of these things might be triggering, but we might see ourselves in them, and also some of the people that we serve. So those are some of the essays that they came out with in 1986. But over time, next one, the essays have expanded. If you look at the first picture, I mean the first part, number one, they talk about these adversities, but within the household level. And these adversities, what they do is that they affect the children, adults, basically harm children, adults, families, organizations, systems, and the entire community. And they're different. There's one within the household level. There's number two within the community. Number three, environmentally, issues of floods. And number four, from an African context, you can see colonialism, intergenerational trauma, and so on and so forth. So these are called adverse childhood experiences, and these are the social determinants of mental health, as it's known right now. So what happens to an individual if these ACEs are not intervened properly? The next slide. And that is what, in a continuum, we call a mental health. In different stages of our life, developmental stages, they affect you, they hit you, you develop certain, you manifest certain maladaptive behaviors. For example, you start having emotional deregulation at a certain age. As you develop, as you grow, ages from 8 to 13 years, there are issues of mistrust of adults and authority. There is an aspect of bullying that comes into play. And somebody, as they grow, there is petty offenses. Now this becomes manifestations. And these are what creates or drives people into crime. And perhaps at that age of 25 and 40, you start seeing they look like GBV. They look like homicide, whether it's filicide, whether it's patricide, whether it's femicide, or suicide. And crime in the bigger picture, and imprisonment. And as you develop later on in life, they create what we call disability-adjusted life years. They become a comorbidity for these diseases. And this is what, like we say in law, justice is blind to those issues. Justice does not see that, because we mostly, in our traditional way of administering justice, we look at issues of evidence, facts, and so on. We don't look at the underlying social issues, social drivers that could have led people to commit crimes. More often we don't do that. And that is, the next slide, please, sorry. Basically, that is what our inmates exhibit. If, for example, you took a number of inmates, let's say 10 of them, and asked them certain questions, for example, where do you come from? Majority of them will never tell you I come from Runda or Karen. Majority of them will say I come from Dandora, Kibera, and so on. What is your level of education? Perhaps out of 10, one of them has a college certificate. The education law, because they were affected from childhood with the adversities. If you live in a house probably that has an alcoholic person and so on, it tends to affect your memory, cognitive abilities, and therefore you cannot even understand numbers properly. In more often than not, you end up even dropping from school And so they are related. Poverty, these are the same people who are in prison. Where do you come from? How is your family? They are poor. What has happened to you? In most cases, they have been abused themselves. What do you miss? Love, abandonment, rejection, and so on. And I just put that quote from Hillary Clinton when she was campaigning in 2015. In this context of America, that's what she said. Our prisons and jails are now our mental health institutions. So what are some of the proposals that we are bringing forth in this session? We know basically that's what our traditional courts do. We educate disputes between people or laws of contract, damages, and so on. But for us to achieve the vision of social transformation, we need to redesign the courts. And there's a concept, I believe some of you have interacted with it, it's called the therapeutic jurisprudence. And these are therapeutic approaches that the court can apply to handle some of these social issues that come into court. They appear like suicide, they appear like GBV or other crimes, but they are actually social in nature. We can redesign how we handle legal rules, judicial practices, and so on. We can create problem-solving courts. We have them already applying these principles, for example, the gender-based violence court, but they need to be enhanced. In the US right now, they have about 300 mental health courts, and they have come in handy to solve some of these disputes, which are social and psychological in nature. And of course, the other thing is what we are currently doing, as in line with also CRPD, is to capacity develop judges, magistrates, lawyers, prosecutors, the police, and so on, with tools of assessment, which are more inclined towards social inquiry, the background of a person, and so on. And lastly, of course, promote prevention of crime within the community. Hardly, maybe it's happening, but hardly do you see maybe judges, magistrates within the communities or in schools and so on. Lately, I've seen, the other week, or coming towards these sessions, we've seen quite a number of such activities. But we feel like the judiciary can use more of the probation arm as a social function or awareness public angle to reach out to as many people, especially in schools and so on. I think I'm done. Thank you so much.
I think we've done well in terms of keeping time, but I want us to transit into Judge Ougo's panelists so that we can combine the plenary together. Is that working well for us? Because these topics are related, but I've learned a new thing called capacity. And I've learned that if Mr. Mutiso saw me when I was in the village, childhood trauma, we'll pick it up. So just keep your questions ready. Once we transit from Judge Ougo, then we'll combine the two sessions together. Thank you. Clap for me.
Thank you, Judge. Good afternoon, everyone. Are we sleeping? PJ has directed me to direct you to stand up and stretch. Yes. Sorry? You draw a coconut. Judge, come, Judge Grace, and help me draw the coconut. Yes, Smama, PJ's orders. See, Ougo.
See, as we just do.
Clap for her. Okay. My panel is going to discuss sexual and reproductive health as a human right, advancing access, equity, and employment. If I could ask my panelists to come up, Lady Justice Wilfrida Okwany Osodo. She'll be followed by Ms. His Ham. and Alan Maleche. Mr. Alan Maleche. I'm being told that Nerima Were is joining online. Technical guys, is she online? I'm under strict instructions not to read any bio. They're on the screen because we are saving on time. I think the first one that should come up is that of Lady Justice Okwan, be followed by Miss Hishram. Okay, she said I can call her Said. Thank you. And then Alan Maleche, Mr. Alan Maleche. When Miss Were comes on board, she will be reflected. You each have 10 minutes, and Judge, you'll be the first one to start. As the President said by Judge Wakiaga, I'll not time you, so you muwe mkiangalia saa. I time you. Aya. Go ahead.
Do you have slides? Thank you. You have to press.
Thank you, Session Chair, Judge Ougo. My topic, I'll ask the Secretariat team to send me through the slides. My topic was the role of the High Court in promoting sexual and reproductive health and rights. I'll start by saying that whether we acknowledge it or not, we are all products of sexual and reproductive health rights. And whether we recognize it or not, if you are blessed to be a parent, you are capable of doing that because those rights were upheld or were observed. So straight, I'll go to the definition aspect of my presentation, which is what the United Nations Interagency Task Force says about the definition of reproductive health. And just to bring the point further home, the right of access to appropriate healthcare services that will enable women to go safely through pregnancy and childbirth and provide couples with the best chances of having their babies. Of course, there's also the World Health Organization definition. And then sexual and reproductive health rights, what it includes, is the right of individuals to make informed and independent decisions about their sexual and reproductive health without discrimination, coercion, or violence. The right also ensures dignity, equality, and autonomy for all individuals. It includes access to comprehensive healthcare services, education, and legal protection related to sexual and reproductive health. And it goes on to talk about safe motherhood, prevention and treatment of sexually transmitted infections, including HIV and AIDS. So then we'll also look at the legislative framework that we have. And in this regard, I looked at the provisions of Article 43, Sub-Article 1 of the Constitution on the right of every person to the highest attainable standard of health, which includes the right to healthcare services, including reproductive health care. I also looked at the Maputo Protocol over the same subject. When we talk about Article 43 of the Constitution on the right to health, you will realize that our circumstances as a country, we are not yet there. Even just going by the kind of hue and cry we've had with the SHA and SHIF program. So the role of the court, and that is the High Court, in promoting SRHR, I will, in my presentation, borrow the words of Professor Ambani and take the jury optimist approach as opposed to the jury pessimist approach, and just highlight instances where our courts have done an excellent job in promoting the sexual and reproductive health rights. The court has been on the front line in addressing violations of sexual and reproductive health rights, such as forced sterilization, discrimination, gender-based violence, lack of access to safe abortion, and denial of contraceptive services. The court has also reviewed and invalidated policies and laws that infringe on those rights. For example, policies or laws that limit access to family planning services if they are inconsistent with the constitutional guarantees or international human rights standards. I looked at the case of AIDS Law Project versus Attorney General. The court has also ensured the implementation of international treaties in Kenya as a signatory to such treaties. Close to my thoughts was the CEDAW, ICESR, and Maputo Protocol. I noted that there are, however, challenges which have been talked about even earlier by speakers that came before me. These challenges to the realization of the rights include lack of adequate resources, cultural and political barriers, resistance to certain provisions, especially on safe abortion, and gender equality in some conservatory societies. Of course, we are all aware of the LGBTQ rights, which is also a hot, controversial topic. I've looked at case law where courts have made pronouncements, like the case of Matthew Okwanda versus Minister of Health and Medical Services and others, where the court, in recognizing the international treaties, referred to the General Comment number 14 on Committee on Economic, Social and Cultural Rights that recognizes the rights to health, that the right to health is closely related to economic rights and is dependent on the realization of other rights, including the right to food, housing, water, work, education, and all that. I will not tire you with the decision of the court in that you will be able to look it up at your own time. Then there was the case of FIDA, JMM through PKM, and others versus Attorney General and others, where a 5-judge bench of the High Court really discussed at length the role of the state in enacting and enforcing laws and policies that protect women and girls from violence and abuse and provide appropriate physical and mental health services. If you read the facts of this case, if you are not moved to tears, then you will be having a heart of stone, because when you read the facts, what a little 14-year-old girl went through as a result of lack of safe abortion in our hospitals or in our healthcare is anything but excruciating. So the court dealt with the issue of safe abortion in that case. Also, there was the case of JOO, known as JMM, versus Attorney General and County Government of Bungoma, where the court held that the right to health care encompasses proper treatment at hospital, availability of necessary equipment, facilities, and medication, and that failure by a hospital to provide basic provision, such as drugs, was a violation of the rights to health. So in this case, the court emphasized or played its role in advancing the rights to health. Then the court also issued guidelines for obtaining consent in a bid to the protection of privacy or the right to make informed choices. The court gave a raft of guidelines on what is expected of a medical health practitioner in obtaining consent of a patient before conducting certain procedures. So if you look at this and you compare it with the decision in the FIDA case, you will notice that had the healthcare provider complied with those guidelines given by the court, what happened to that little girl would not have happened. Then, of course, my presentation also juxtaposed our decisions with the famous decision in Roe versus Wade, a US Supreme Court case, where the court also dealt with the issue of abortion, safe abortion, and the right of an individual to access abortion. Of course, the case was overturned in a later case that was decided in 2022. But then again, there we are. I can say that we have done well as a court in our role of enhancing SRHR. Thank you so much.
Thank you, Judge. Ms. Said will take us up on the law and FGM. Karibu, Ms. Said.
Thank you very much. Good afternoon, everyone. All protocol observed. My name is Ilham Hisham. I'm representing FIDA Kenya, and I'll be discussing FGM and the law. I don't know if the ICT team can open up my presentation, kindly. So as pertains FGM, I just wanted to take us briefly through what FGM is about and the types of FGM. Then we'll cursory look at the international and the regional instruments, as well as some of the declarations and resolutions that have been made, then make a case maybe vis-a-vis the other East African countries where we are as a country. So generally there's been over 200 million girls and women today that have undergone FGM. The number might not spell what it actually is, but once we know what actually they undergo as far as FGM is concerned, then we'll be more and more worried as to the numbers. Considering in Kenya, the statistics are that 4 million girls, as per the KDHS of 2014, that's the health survey, 4 million girls and women in Kenya, including those from 22 high prevalent counties, with 21 girls and women aged between 15 and 49 years had undergone FGM. I don't know if it's the sitting position, but the remote is refusing to click. So some of the drivers include, sorry? No, it's okay. Some of the drivers include ladies and girls being prevented from precarious or sexual exploitation, and ensuring that they have their virginity before they get married, and a right as a rite of passage. Apologies for that. So this is the trend. I will share the slides, so in the interest of time, allow me to just skim through. The trend for FGM, starting from 2004, 2008, and then coming to 2011, the trend has been on a decline, probably because of also the investment of the government in ensuring that FGM is highlighted and abrogated. When it comes to the emerging trends, we have the age at FGM. This is the age whereby now we see people are being circumcised at infant age. There is a cross-border FGM where now perpetrators are taking the survivors to different countries and counties that do not practice FGM. So this is a new emerging trend. For our northeastern citizens, most of them, they bring their children from US, UK, and other places to come and conduct it in Kenya, in places where FGM is not being conducted. There's also change in the types of FGM. So somebody, maybe they have type 1, and then now somebody does type 3 on them. Medicalization of FGM. 15% of FGM cases were performed by medical professionals. This is as far as the health survey of 2014 is concerned. Then there's also an emerging trend in terms of FGM in emergency and humanitarian contexts. For instance, during the period of COVID, people are more concentrating on COVID and the cases thereafter, but not as far as SRHR issues were concerned. In fact, we were at another seminar yesterday where we realized that 2020 and 2021 is the only period where femicide cases were at a lower rate as opposed to the other years. So the media was more pronounced in highlighting the cases of COVID as opposed to the SRHR issues during that period. So FGM, in Kenya, we have the Prohibition of FGM Act, which was established in 2011, enacted in 2011. We have the types of FGM. The clitoridectomy, this is the partial or total removal of the clitoral glands. Then we have type 2, which is excision. This is the partial or total removal of the clitoral glands and the labia minora. Then we have infibulation. This is where the vaginal narrow opening is covered with a seal. Sometimes it is sewn so that somebody cannot be able to have penetration. And then there is type 4, which is others, where there is piercing, incising, and scrapping. So this is the types of FGM. So there is type 1, 2, 3, and 4. So type 3 is the infibulation, where somebody is just sewn totally. So what are the signs that somebody has had FGM? They normally have health repercussions, and these are some of them, including issues when they are menstruating, giving birth, or urinating, health consequences including death, apart from HIV and AIDS. Then we had the case of Dr. Tatu Kamawi in Kenya, where the 3-judge bench ruled in favor of against FGM. If the ICT team can play for me the third video, kindly. So in the Dr. Kamau case, the court reinforced the aspect of Article 27 and Article 28 of our Constitution as pertains discrimination and issues of right to dignity. In as much as an adult has the right to consent, that consent has to be measured in accordance with the rights and protection of the others in the community. So while they set up the video, allow me to proceed. Approaches to FGM, there is the human right-based approach, intersectional and survivor-centered approach, as well as trauma-informed practice. Some of the international instruments includes the UDHR. Article 25 provides that everyone has the right to a standard of living adequate for health and well-being. We have also the ICCPR. Article 2 provides that discrimination on the basis of sex mandates the states to ensure that any person whose rights of freedom as herein recognized are violated and shall have an effective remedy. We also have the preamble to the International Covenant on the Economic, Social, and Cultural Rights, which also talks about discrimination. Then we also have CEDAW, the Convention on Elimination Against All Forms of Discrimination Against Women. In as much as it does not explicitly define FGM, it provides for discrimination and harmful practices. We also have the Convention on the Rights of the Child, which places the government as the ultimate places the government's responsibility to ensure fundamental rights of the children are recognized and protected. Then we have the international instruments, including the European Parliament resolutions on FGM. We can have a look at that at our own time. Allow me to proceed. We have the Beijing platform on Fourth World Conference on Women, whereby we're discussing about harmful aspects and the rights of women, that FGM should be prohibited and eliminated. The UN General Assembly pertaining to elimination of violence against women, and the Commission on the Status of Women as well, which advocated for the ending of FGM. For the regional instruments, we have the Banjul Charter, we have the Maputo Protocol, we have the Charter on the Rights to the Child, we also have the Ouagadougou Declaration and the Cairo Declaration as well. On the Maputo Protocol, Article 5, Sub-Article B, clearly provided for prohibition through legislative measures backed by sanctions of all forms of FGM. So this is the first regional instrument that explicitly provided against FGM and sanctions thereafter. There is also abrogation of rights. So some of the rights that one is abrogated as pertains FGM include the right to be free from all forms of discrimination, right to life, right to freedom from torture, the right to health, the rights of the child, as well as right to dignity. Some of the best practices include enactment and implementation of laws and policies in Kenya.
International law, it's no longer arguable. It is in a number of instruments, has been interpreted by a number of treaty monitoring bodies at the international level and regional level as well. I wanted also to highlight the right to reproductive health, which is the focus of this panel, and that this is established under Article 14 of the Maputo Protocol. It is extremely comprehensive and has been lauded as one of the most progressive in the world when it comes to the right to reproductive health. I would have loved to read clause by clause, but the 7 minutes was quite pronounced, so I will also skip through that. So going into the crux of my presentation, just highlighting a few of the issues that courts have interrogated when we look at international treaty monitoring bodies as well as regional ones. There are a few issues when it comes to maternal health care, maternal mortality, obstetric violence, teenage pregnancy, and youth-friendly sexual and reproductive health services. And then most interesting is the inevitable tie between sexual violence and the right to comprehensive sexual and reproductive health services. So the courts have really tried to look at how to tie these to the right to reproductive health. And in one of my slides earlier, I had mentioned that the right to reproductive health is inextricably tied to the right to life, the right to dignity, the right to be free from cruel, inhuman, and degrading treatment, as well as very many other rights that are crucial for a dignified life. So the presentation was really about getting into the jurisprudence itself. And this is very exciting for us in legal practice to see how the jurisprudence has developed. And so I picked a few landmark cases that have been decided. So the first one was Aline Pimentel versus Brazil. And in this case, the CEDAW committee was looking at maternal mortality, and they said that it is actually the states that have a human rights obligation to reduce maternal mortality, to ensure women's rights to safe motherhood, and it was actually also an obligation of the state to provide access to adequate emergency obstetric care. So it was not enough for the state to say that, this is an issue of progressive realization, they're doing everything that they can, and try to chalk it down to medical negligence. The committee was emphatic that this is an issue of rights and rights being upheld. So then the next case I would like us to look at was again before the Inter-American Commission on Human Rights, and this was a case on forced sterilization. I think my colleague Alan may have spoken about this in the Kenyan context, and this was also happening in Peru in 2003, and this was quite a while ago, where the parties came to an agreement, and Peru was urged to take into account human rights standards in revising its laws and policies on reproductive health and family planning. It was also tied to issues of equality and discrimination for women, which has come across all these cases, particularly the ones before the CEDAW committee. There's been quite progressive interpretation of the tie between the right to equality and the right to reproductive health. So from a human rights standard, it is very clear and very easy to draw that line and see where the duties lie, what the obligations are, what the standards would be for implementation by the state and what a failure to implement those standards look like. And I think that was highlighted in this case. And then we have the European Court of Human Rights. So I went up and down a lot of the regions and the international level as well, just to show how the courts have managed to navigate and come to a very clear standard, which is the human rights standard, which I was just speaking about earlier, the non-negotiable, let's say, or the minimum standards that must be met. So in this case of RR versus Poland, there was an issue of access to information, and it was about whether the person who was before the court was denied information that related to her obstetric care, and the court held that the state that was before it was actually in violation of human rights standards and
IT, has she gone off? She's frozen.
Sorry, I dropped off. Can you hear me now? I'm back.
Yes, we can.
Okay, excellent. And then in another case on the before the European Court of Human Rights, there was a question of the rights of adolescents. And I think this has been quite contested when it comes to what policy should look like. How far should adolescents be able to consent? What is the concept of bodily autonomy when it comes to adolescents to access comprehensive sexual reproductive health information and services? And the court affirmed that young people do have autonomy when it comes to their reproductive health. They should be able to access youth-friendly services, information, counseling that gives them the wide range of services that they should be able to then make a choice as to what is best for them. And then now when we come to our local standards, we had a very interesting case that was decided in 2022 when there was a big issue around Tanzania and access of pregnant girls to school, because the state had a policy where pregnant girls would be banned from returning to school or from attending school. And this was also found to be in violation not only of the right to education, because one would imagine this is purely about the right to education, but the right to reproductive health was implicated quite strongly here, from information that is youth-friendly, from family planning and the right to plan their family, which is also actually guaranteed in the Maputo Protocol. And so the African Committee of Experts on the Rights and Welfare of the Child made a very progressive decision requiring the government to take this into account in their legal and policy framework and implementation of the same. It is currently being monitored. The decision is being monitored by the committee as one of their ways of working. And finally, it's not always rosy. We had a decision that was not quite progressive that came out in May this year from the African Commission of Human Rights, where it was the issue of maternal mortality. The rates are very high in Nigeria, and there were claimants before the commission claiming that there was not enough policy and budgetary framework that had been put in place to guarantee the right to life, the right to reproductive health, the right to dignity, the right to equality and non-discrimination. Unfortunately, the commission dismissed the claim, holding that the claimants had failed to substantiate their claims, and also, unfortunately, that they had failed to demonstrate the link between the facts and the infringement that they were alleging, particularly the infringement of rights under Article 14, which I skipped over earlier in my presentation. So while we've had seemingly very progressive jurisprudence, we also have room and quite a lot of room for the interpretation that sits primarily on a human rights making the human rights as the standard of interpretation, and the standards and the normative standards that have been set out in the legal framework is enough for judiciaries and judges present to make the decisions giving enough credence not only to these legal frameworks but the jurisprudence that has already been decided. My final slide, I'm actually done. I just wanted to say an honorable mention that we've had quite a few decisions. I just picked out a few that have been decided by our Court of Appeal and our High Courts that I'm sure are familiar to the room, and I think other speakers have spoken about that we are on the right trajectory, but there is still quite a bit that needs to be done, particularly on the issues that I've spoken about, the access of adolescents to youth-friendly services, maternal mortality and maternal health and mortality, and obstetric violence. So I thank you for your time, and back to you.
Thank you, Ms. Aching.
Thank you.
Thank you. This is an interesting topic, but hold your questions until you're allowed to ask them. Let's give a clap to the panelists so that I can hand over to my brother who is coming in next. An organized clap, please. 1, 2, 3. Yes, thank you, thank you. Judge Moses Ado, or Adu.
At least I'm lucky today. No one has said without much ado. Now, I am here for the next session. It's on balancing justice and human rights, examining death penalty and its implications. I will introduce my panelists. The bios, I believe, will be running, if they are not already running on the screen. We have His Lordship, Justice Kanyi Kimondo, who will be our first presenter. But I think the rest can also move from ICJ. We have Julie Matheka. We have Irungu Houghton, Mark Barasa from ODPP. Yes, I think those are the 4 that we have today. Bwana Irungu, karibu. Barasa, karibu. Julie, okay, now we have the 4 of them. I think as the previous panelists, we will have, with the permission of the PJ, 10 minutes. You may begin, His Lordship.
Good afternoon. It gives me great pleasure to speak to my brothers and sisters this afternoon. I will not be putting anything on the PowerPoint in the interest of time, but I want to say the following. The death penalty is applicable in Kenya for 5 categories of offenses. We have treason under Section 40 of the Penal Code, oathing to commit a capital offense, Section 60, murder, Section 204, which all of you brothers and sisters tried at the High Court, robbery with violence, and attempted robbery with violence. That's Section 296, subsection 2, and 297, subsection 2. This punishment dates back to the year 1893, just about the time some of you were born. However, the last executions in the Republic of Kenya took place in 1987. It is not very certain, but I believe it was the turn for Hezekiah Ochuka and Pancreas Oteo Okumu following the aborted 1982 coup. Since then, there has been no further execution, and we have had a number of intervening presidential moratorium. for instance, in 2009 by His Excellency Mwai Kibaki. The method for execution in Kenya is hanging by the neck, and it is largely rooted in retribution, and obviously it has significant impact on the well-being of the convicts and their families. Arguments across the aisle on the suitability of this punishment are very forceful. They range from a human rights perspective, that is the inhuman or degrading nature of the punishment, its irreversibility, and dehumanizing nature, particularly for people who have to wait for a long time on death row. Commuting of the death penalty to life, which has been the common practice in Kenya, also means that the offenders continue to serve, oftentimes, an indeterminate sentence. The Moro Teto case, which are framed as part of my topic, did not define that period on grounds that what should constitute a life sentence was not a matter that had been conversed through the High Court or the Court of Appeal. In fact, the court said, and this is good for you brothers and sisters, that it needed to learn from the jurisprudence of this court. In fact, in paragraph 78, they said, a critical issue such as this, where legislation is to be examined, is deserving of the reasoned and well-thought arguments of the petitioners, the DPP, and other interested parties, all amicus curiae, at input of the High Court and the Court of Appeal. So returning to the issue then of the death penalty, there are still arguments again on the other side, that there will be some cases when it's truly deserved. Some murders can be quite gross, some can be fully premeditated, and I've given the example of a decision that I had to painfully make in Eldoret in 2016 in Republic versus Josephat Kipkoech Kirwa, where the deceased was accused of having bewitched a neighboring family. And the key witness last saw this witness hanging upside down on the rafters of a small hut, pleading for mercy and water. The next morning, the witness said that she saw a huge bonfire in that house. And the only thing that was recovered was a few bones. So I said in that particular case, the death penalty was deserved. Remember, this is post-Moro Teto. And the Court of Appeal in Nakuru, just this year, upheld that sentence. So there are those arguments, and we have to keep them in mind. Although I've made reference to the Moro Teto case, I'm not about to discuss the merits of the Moro Teto case. This is not also a discussion or the interpretation on the Court of Appeal decisions and the High Court decisions that have interpreted Moro Teto to mean that by way of parity of reasoning, mandatory sentences then interfere with our discretion when it comes to sentencing. It is equally not a critique of the subsequent decisions by the Supreme Court, including the directions that the Supreme Court issued on the 6th of July 2021 in Moro Teto. I've used that decision purely as a marker on the road, some form of milestone that shows that the court had a wonderful opportunity before it, but for certain reasons, it could not do so on the 14th of December 2017 when it made that decision. If you doubt that the Supreme Court had that opportunity, you only have to look at the very first paragraph in that decision. And they said that this appeal raises a fundamental legal issue that has engaged many global jurisdictions in seemingly unending controversy, whether or not the mandatory death penalty is unconstitutional. I only want to say this about Moro Teto. I don't know how many of you remember that this decision was argued twice before the Supreme Court. It was first argued before the bench headed by Justice Mutunga, Vice President Kalpana Rawal, Tunoi, Ojwang, and Wajala J. We call them SCJ. But then, following the retirement of Justice Tunoi, Justice Kalpana Lawal, and Justice Mutunga, the matter was put again to the new bench that now made that decision. Keep in mind that the main provisions that the court relied on in our constitution is Article 19, I'll not go through it, Article 28, Article 50, Article 25 of the Constitution, among others, including various international instruments on the subject. And at paragraph 59, the court merely said that we now lay to rest the quagmire that has plagued the courts with regard to the mandatory nature of Section 204 of the Penal Code. We do this by determining that any court dealing with the offense of murder is allowed to exercise judicial discretion by considering any mitigating factors in sentencing an accused person charged and found guilty of that offense. To do otherwise, we render the trial with the resulting sentence under Section 204 of the Penal Code unfair, thereby conflicting with Article 25C, 28, 48, 50, and 2G of the Constitution. And then they also dealt with Article 27 on discrimination. Let me avoid the final orders that were given in that court, but we are dealing here with jurisprudence from the High Court, and I can summarize it in about 4 bullet points. When it comes to discretionary sentencing, following Mulwatetu, the High Court has consistently ruled that the death penalty should not be mandatory and must be subject to judicial discretion. Courts are required to consider mitigating factors, including the mental state of the accused, the context of the crime, and personal circumstances. The second limb is that human rights and constitutionality are important in these matters. And the High Court has reinforced that the right to life and human dignity must be balanced against the state's interest in punishing offenders. So that while yes, the death penalty is still constitutional, its application should respect human rights and be proportional to the offense. The third leap are evolving standards at an international level towards the abolition of the penalty and the High Court's approach, so that the court has recognized the shift towards restorative and rehabilitative justice, including alternative justice systems, rather than retribution. And then finally, for the High Court, I would say that when it comes to abolition versus retention, while yes, this sentence has remained in our books, the discussion is still live at the High Court, including for those offenders whose sentences have been commuted to life, Wolile is a life sentence, and there are decisions from this court by Justice Oduga, for instance, and Justice Mativo, as they then were. So where are we now? Coming to the end of my presentation. And we can say the following: the death penalty remains a valid sentence in Kenya. The trial court has discretion on sentencing, but following the recent Supreme Court decision in Republic versus Joshua Gishoke Mwangi, petition E018 of 2023, that logic does not apply to other mandatory or minimum sentences. So what happens to all of those decisions that we have made and that the Court of Appeal has made? And it would seem from that decision then that a properly founded dispute on the validity of the death penalty climbing through the system from the High Court, Court of Appeal, all the way to the Supreme Court may give the Supreme Court one other opportunity to re-examine the validity of the death penalty. Finally, ladies and gentlemen, in 2023, 4 bills were presented in Parliament to abolish the death penalty. And these included the Preservation of Public Security Amendment Bill, the Legal Aid Amendment Bill, the Prisons Amendment Bill, and the Penal Code Amendment Bill. I'll only talk about the last one. The Penal Code Amendment Bill was published on the 1st of September 2023, and it was sponsored by the Honorable Opiyo Wadai, now Cabinet Secretary. The first reading was in October 2023. In Section 3 of that bill, it sought to delete the word death in Section 40, Section 60, Section 204, 296, and 297 that I've dealt with above, and to replace them with a life sentence. This bill, unfortunately, ladies and gentlemen, has gone mute. And I can only theorize that it might have something to do with the Honorable Opiyo Wadai having now become a Cabinet Secretary. Thank you very much.
Thank you. Let's give him a round of applause. Thank you so much. Our next presenter is Julie Matheka, who will be dealing with emerging comparative jurisprudence on death penalty from other countries. Karibu, Julie.
Thank you very much, Judge. I will also not be sharing a presentation on the screens. However, I will be making a few notes. It is a pleasure addressing you today, my ladies and my lords. I am a product of the judiciary, having worked for a little bit at the Kenya Magistrates and Judges Association. So when I sit here, I see my mentors, I see people who have guided me, and I am proud to be able to address you today. I work in the Kenya section of the International Commission of Jurists, and we have been at the forefront of advocating for the abolition of the death penalty as a member of the World Coalition Against the Death Penalty. Part of our work has been advocacy, litigation, training and capacity building, research, and strategic engagements. One of our most prominent litigations is actually the Murwatetu decision, where we were amicus in that matter. In terms of our advocacy, we have actually pushed for the enactment of the Penal Code Amendment Bill that Honorable Justice Kimondo has spoken to. And indeed, there is a challenge because it has gone mute after the then minority leader has moved to the cabinet. And we are still pursuing that, hopefully looking for avenues that we can bring it back to the table, be it through engaging with the minority leader or also just finding a member of parliament who is seized of these issues and quite passionate, because this is a very emotive issue. And I will be able to discuss a few things about why judges should be invested in this discussion. In terms of the comparative jurisprudence that I wanted to speak to, I think the most important one is, for me, the one from South Africa, the S versus Mwakanyana case, which actually then led to the unconstitutionality of the death penalty in South Africa. And I think that is one anchor case that even in our Murwatetu case we anchored on. So that is the first case that I want to discuss. But I want to mention it and move into our own space. I think we heavily rely on comparative jurisprudence a lot, but we have the capacity to make our own jurisprudence. And for me, actually, the presentation, having listened to a lot of the presentations by my colleagues before, I retooled it into what is the role of judges in the discourse of the death penalty? How can we reshape it? And one of the considerations that we wanted to put to the floor is that the irreversibility should be a concern. The Death Penalty Project actually issued that in the last 1 year, in the last research that they have done, over 200 convictions were actually errored. So people have actually been executed, yet they were actually innocent. So the irreversibility of the death penalty should be something that concerns us, because once the evidence comes to the floor, there's nothing we can do, having already done the execution. This year, the World Coalition actually commemorated its World Day Against Penalty, anchoring the theme around whether the death penalty is deterrent. We have research showing that the death penalty no longer serves a deterrent effect. This research has actually been also done by the Kenya National Human Rights Commission, who actually said that indeed it does not offer a deterrent effect, because at the point of commission of the offense, the person did not know that they would actually get a death penalty. So it was not a deterrent. They actually thought they would get arrested and imprisoned, which scared them more than the death penalty. The other important issue is the violation of human rights in totality, and I think the Honorable Judge has spoken to it, which is the fact that as judges, we need to preserve the right to life, and actually imposing the death penalty is a violation on the right to life. But allow me to move further into the various rights, which is actually, one of them is the right and a freedom from cruel, inhumane, and torturesome experiences, we find that the mental anguish of persons who are on death row is actually construed as torture. These are people who are left in a state of limbo, not knowing when the execution warrants shall be signed, if they shall be signed, and when they shall be signed. And when you speak to a lot of them, they actually say, at this rate, they would rather be executed than continue to wait. So there is indeed a greater violation that we perpetuate when we sentence persons to death. An important aspect that we as ICJ have identified is the discrimination lens. We find that a lot of the persons who are on death row are from poor, vulnerable backgrounds. They did not have access to legal representation. They were not even informed adequately of what the crime before them could amount to. So they were not aware of the legal process. Not only did they have legal representation, but they were not aware of the legal process in itself. And then within the criminal justice system, from point of arrest, they have suffered grave violations. So you find that poor and vulnerable persons who are within the criminal justice system are actually targeted disproportionately by the death penalty still being in place. There are also preconceived biases in sentencing. It's interesting that when you put two judges, and now in my case we have 100 judges in the room, and you present the same sets of evidence, you will all rule differently, which is a challenge. So there are inherent biases within each and every one of us, and that does present, and particularly could be a challenge in regards to the death penalty. There is the economic cost argument, because capital punishments are significantly more expensive than life imprisonments due to the lengthiness of the trials, appeals, and the procedural safeguards. Judges argue that these resources could be actually better allocated to crime prevention and rehabilitation programs. There are the global and regional trends that are currently emanating. There is a global push towards abolishing the death penalty worldwide. Indeed, there are certain countries that are still retentionists, but indeed in the international spaces and the forums, you will find that a lot of countries are actually putting recommendations to states to abolish the death penalty, and as such, increasingly we are seeing a push. In Africa, we have over 20 countries that have abolished the death penalty, and the momentum is growing. Kenya will be up for its universal periodic review next year, and I do believe strongly that one of the recommendations that will come from the member states is abolish the death penalty by signing on to the second optional protocol of the ICCPR. We do know that indeed this recommendation has come more than once, but Kenya has refused to sign on to it. But increasingly the pressure from neighboring countries may actually push Kenya to sign on to it. The fact that the death penalty is actually incompatible with rehabilitation. The death penalty denies individuals the opportunity to rehabilitate and reintegrate into society. Now we have a difficult and thorny issue, which is the public opinion and evolving social norms. I would admit, and as a person who's an abolitionist and as an institution where I come from being an abolitionist, that indeed we have a challenge in terms of public perception and the death penalty. And it would be remiss if we did not address it as institutions that are pushing for the abolition of the death penalty, because there are people who still believe in it. But it is our work to continuously change the minds of people by actually clawing back at certain norms. So whereas it's increasing towards the opposition of the death penalty, we have to admit that it's moving at a very slow pace. We have actually looked at the fact that a lot of victims have said that the death penalty is re-traumatizing. The fact that they have to come to court, listen to lengthy appeals, the testimonies, listen to what happened to their kin and the evidence being adduced by the prosecutors and other parties, they do get re-traumatized. And as such, for them, it isn't an issue of closure. And I know from a legal perspective, sometimes we assume that giving the death penalty can help the families actually get closure. In certain instances, it does not. It actually leads to re-traumatizing them. Allow me to actually go into a different set of conversation. And this is what is emerging and that we need to be concerned about as justices, which is the fact that the death penalty is being used in various ways. So there's an emerging trend of death penalty and counterterrorism. We have noted that in certain countries, they have actually expanded the number of cases that could actually, the number of offenses that draw the capital offense of and get the death penalty. For example, drug-related crimes. And for some of these crimes, you actually see a lack of fair trial processes. in them. So it's important that as judges, as you sit and work, you are aware that in certain instances, you might be presented with situations where there's a call for an expansion of sentences, bringing some into the ambit of the death penalty, and you should be aware to resist. There is the use of death penalty in authoritarian regimes. I am looking at Judge Ado and I can see that my time is running, but I will be brief. The use of death penalty in authoritarian regimes. Some authoritarian regimes and governments have used the death penalty as a tool to suppress political dissent and eliminate opposition and silence activists. So the death penalty is being used as a tool, and that should be concerning. There is also the nuanced issue of women and the death penalty. I am proud to say that Kenya has actually produced one of the most progressive decisions in the issue of gender-based violence and women in the State versus Trufena Adonga case, whereby gender-based violence was actually considered as a mitigation. And these are some of the conversations that are happening globally. How do we ensure that women who are facing gender-based violence, who are actually being persecuted, can use this as a progressive defense? In South Africa, they have the battered women syndrome. Is it time that we adopt such mitigation? Lastly, I want to actually echo what my colleague Matthew said, which is the question of mental illness and death penalty. How do we ensure that our courts and our systems are catered to persons who have mental disability, who often face a capital offense because of the nature of their disability vis-a-vis the offense? How do we ensure that they are protected as a vulnerable population when they come before the courts? I started with the issue of poverty, and I want to just state back that when we did an audit of the national criminal justice system, we found that a lot of persons who are incarcerated for petty offenses were poor and vulnerable persons. We also looked at the persons who were incarcerated and detained on death row, and it was a similar situation. They were from poor and vulnerable backgrounds. Therefore, there's a growing and significant trend that certain offenses are actually affecting poor and vulnerable persons, and there's need for us to raise the concern and move away from that and ensure we protect poor and vulnerable people on this lovely International Human Rights Day. That is my presentation. Thank you.
Thank you. A round of applause for Julie. Our next presenter is Hirungu Houghton. He'll be looking at the impact of retaining death penalty on human rights. Karibu Hirungu.
Thank you very much, and good afternoon, and happy International Human Rights Day to all of you. What a better way to spend it than actually among judicial officers and judges. So I'm very, very happy on behalf of Amnesty International to be with you this afternoon. I was released actually about 2 hours ago from Central Police Station, and one of the arguments that I made was that I was coming to speak before you all, and I think there was great fear among the officers there. What took me to Central Police Station was not planned. I woke up this morning being very worried about Article 26.1, Article 27.2, the two articles that give rise to the right to life, and also the right to equality. And as you, I'm sure, are all very aware, we have been struggling with a rising spike in the number of gender-based violence cases, and also femicide. 97 cases in 90 days, according to the Deputy Inspector General. So I chose to join a group of about 600 protesters that declared that they were going to essentially raise this issue. One of the places that they were planning to go to was the judiciary. So when I heard of the plans, I told them probably a better place would have been to try and come to Safari Park, because all the people you want to talk to would be there. But there was something about the distance from CBD to Safari Park that I think even an Amnesty member would give up. I tell the story a little bit because I think we are living in extraordinary times. We are living in moments, particularly over the last 6 months, where we have seen no less than 2,000 charges against non-violent, peaceful protesters, essentially for expressing one of the most important articles in our Constitution, that is Article 37. Many of those cases came before you over the last 6 months or more. Protesters were charged with unlawful assembly, robbery with violence, failure to notify the authorities, and causing a disturbance. And I think there was a few others there. 4 months ago, Justice Bahati Nyamuye, who may be in the room, I don't know if you are here, Justice, but I wanted to acknowledge you. She's, I think, among us, was among us. She ruled in a case that I thought was going to be a landmark case, that the Inspector General would be barred from deploying police officers who are non-uniformed and essentially driving vehicles that were unmarked. 4 months ago, I am a living testimony, thanks to God, that this practice still remains. I was bundled into a vehicle by officers that somehow have either run out of uniforms or decided this morning not to wear uniforms. Just a side note, and then I will come to the topic for this morning. There were more protesters proportionately in T-shirts than there were officers managing the protest and the public order today that were in uniforms. So I raise this because, I think for many of you, you are people that believe in the rule of law. You are human beings that believe in the rights of human beings. I mean, that I'm sure has been the calling of many of you to the vocation that you have taken on. But I think, again, we are living in extraordinary times, and I would request you all to be very vigilant around some of the sacrosanct freedoms and fundamental rights that we have in our Bill of Rights. With those few remarks, and partly this was me venting. I'm told by the councillors it's good to vent from time to time so that you can get it out. Last week, Justice Kanyi Kimondo and myself were the guests of the state. We were at Committee Maximum Security. We shared not quite the same cell, but we were in a public space. And we had the joy, really the joy, of watching 29 death row prisoners and prison warders being awarded degrees, law degrees from the University of London. Among the 29 was a young woman called Ruth Kamande. And Ruth Kamande, many years ago, Amnesty rose to condemn the application of the death penalty in her case. Her case was a very troublesome case. Her boyfriend, Farid Mohammed, was stabbed 25 times. It was a matter of concern for the court that the both of them were on substance abuse, and they had had a very vicious relationship. She was sentenced to death. I walked up to her. I'd never met her, although we campaigned for her back in 2016. I walked up to her and said, the reason why I believe in the abolition of the death penalty is because you are standing here today and you are now a graduate of the University of London. I can't tell you how important that is. This was not your model prisoner. She was difficult. Parole reports suggest that it took her some time. In fact, she said herself two things that I think it's important for us to contemplate on today. She said, thank you to her parole officers for believing in her in a manner in which she did not believe in herself for several years on death row. And then the other thing that she said to me, which is so typical of all the cases that come before death, who are punished with death. She said, I have had no opportunity to read the Constitution or any law, any legal instrument, until I was condemned to death, and I took up this legal education program. And I want to start there because I think sometimes the statistics don't tell us the story. You have to understand the importance of transformative justice and correctional reform in the life of a single individual. Let me, having said that, turn to some of the statistics. We know, and we've been told by Julie, that last year there were about 1,153 judicial homicide cases. People sentenced to death. This is the highest in a decade globally. Right? Let me start again. Despite all that we say about the death penalty becoming an outmoded, cruel, and inhuman form of punishment, and many countries moving away from it, the reality is last year, we had the highest number of cases of people who were executed for some crime or the other. In Africa, the number of executions tripled over the last year. Tripled. Now, let me contextualize these figures a little bit so that you get the sense. The 38 executions that took place last year, which are the tripling of the cases, took place in one country, and that's Somalia. So generally speaking, most of Africa has either gone abolitionist or it is essentially retaining the statutes but not committing judicial murder. Most of the cases in the world are coming from 2 or 3 countries, mostly the Middle East, the United States of America, and China. But lest we feel any sense of comfort in those 2 qualifying comments, let us be clear that the 2 world powers today are China and the United States of America. We do not know what is going to happen when a new administration takes place in the next few weeks. So I could talk about the violation of human rights, the violations of international human rights standards. I could quote many of the instruments that you are all too aware of. I could quote the Kenyan National Commission for Human Rights studies, the 2 studies that have been done in 2023 and 2022 that show that up to 40% of the Kenyan public no longer believe in administering the death penalty. That 10% in addition are actually now concerned about whether we should retain it or not. Or that let me give the figure again. Something like 1 in 2 Kenyans who are on death row do not feel that the death penalty, when they committed the act, was a deterrent. These are statistics that are qualified and carried out by independent researchers, not by Amnesty. 90% of the people on death row, the 100 or so that are in our prisons at the moment, 90% of them are undereducated. They are primarily poor or from humble backgrounds. 50% of them are addicted to some substance or another at the time that they were arrested. And 89% were supporting families while they themselves did not have jobs. So I have to implore on you to reconcile that most of the people that we're committing to death are essentially poor people, completely underrepresented in your courts, and essentially people who don't believe that if they are sentenced to death, it will stop them from carrying out crimes. Most of them were first-time offenders. I think that's the other thing to mention. They're not hardened serial criminals. Most of them are first-time offenders. So I'm going to stop by just referring back to Justice Kimondo's reference to those 4 bills. And I know many of you here are abolitionists. You are trying your best within the laws that you have been provided. So part of the responsibility of Amnesty International and others is to rise again to go to Parliament, like we did on the 4 bills, and to give a memorandum. Perhaps we need to go and see the good Cabinet Secretary and say his work is not yet done in the National Assembly. Delegate, relay race, pass it on to somebody else. And we need to press for just 3 things. The first is, can we abolish the death penalty for all crimes? Can we do a legal audit of all laws? And let's not forget the Armed Forces Act, and in particular, the Section 15 and Section 25 and the others. Because the last time somebody was hung in our name, it was under that instrument. But most importantly, let us go to Parliament, let us reach out to the new Attorney General, she's still new, and let us ask them to accelerate the definition of life imprisonment and also introduce instruments that outlaw the death penalty forever. Thank you very much.
Thank you, Irungu. The next presenter is, I think I lost it. Yeah, Baras, sorry, from the ODPP. The role of ODPP on capital punishment.
Thank you very much. On behalf of ODPP, it is a pleasure to join you on this International Human Rights Day. I'm very humbled to be before esteemed members of the bench, judges of the High Court. Anytime I appear before a forum such as this, I feel like I'm back in primary school, where you learn a lot of things, because most of us, prosecution counsel, we began our practice in the High Court. That time, police prosecutors were still prosecuting cases before the magistrates' courts. Before the Director of Public Prosecutions, the new independent office of the ODPP was established under the new constitution, and we took over all prosecutions, even the ones before the magistrates' courts. And therefore, we learned a lot of things in the High Court, and it's always a pleasure, again, to interact with you in a forum such as this. My presentation is going to be on capital punishment. We are looking at alternative justice mechanisms as a tool to bridge the gaps in criminal justice system. I want to start from where Justice Zion left. She talked about the case of Maiso Gwanda versus Republic, the Malawian case, in which a young man was arrested for being idle. He was charged, but the Malawian High Court declared that section of the Malawian Penal Code unconstitutional. Our High Court here in Kenya has similarly declared various sections of the Penal Code unconstitutional, especially in cases where we have tried to criminalize freedom of expression. And today, as we address this issue of capital punishment, the statistics are that around 11,000 people have been charged with capital offenses, robbery with violence. And this is an alarming figure. There is need to address the situation. The law as it is that the death penalty still remains lawful. And therefore, as ODPP, we are trying to look at alternatives to prosecution, namely diversion and plea bargain, as a way of addressing this problem, this gap in the criminal justice system. One of the tools we have developed to address the challenges in the criminal justice system is the decision to charge policy and guidelines. Before a prosecution counsel makes a decision to charge, the prosecutor is supposed to apply their discretion and weigh various factors, including evidence, statistical analysis, whether there are alternatives to prosecution, and other contextual factors before making that decision to charge. And we welcome organizations such as Mr. Maleches, because sometimes when we are faced with offenses relating to reproductive health, such as abortion, the need for an expert is very key to help us understand the contextual factors. Apart from the decision to charge, we have two guiding tests, the public interest test and the evidential test, which the prosecution counsel is supposed to look at before making that decision to charge. Therefore, we also apply alternatives to prosecution, such as diversion and plea bargain. In plea bargain, this is a negotiation between an accused person and or his advocate on the one hand, and the prosecutor on the other, in which the accused agrees to plead guilty or not to contest to some crimes in return for reduction of the severity of the charges or removal of some of the charges, after which a plea agreement can be entered into. The legislative framework, of course, is Article 157, which grants prosecutorial powers to the DPP. Also, the Criminal Procedure Code. The benefits of plea bargaining are that it reduces the backlog in the criminal justice system. It is also beneficial to the accused person because it avoids time-intensive and potentially costly trials. Plea bargain also benefits the judiciary because it helps in the quick and efficient disposal of cases. It is beneficial, of course, to the victims because it avoids re-traumatizing. Plea bargain also benefits the public because it conserves public resources. It reduces and eliminates costly trials paid by taxpayers. When can it be used? When parties are convinced that the evidence will lead to a conviction, when the parties have a joint recommendation on sentencing, and when the parties have different positions on sentencing, such as on the issue of capital punishment. A plea agreement can come in handy. We don't use plea agreements when there is insufficient evidence. It's also not used when charging decision has not been made. It is also not used when there is insufficient evidence. Of course, the participants are the prosecutor, the accused person, the legal representative of the defense counsel, investigative agencies like NPS, the ESCC, and KRA. The prosecutor and the supervisor must also sign the plea agreement. An accused person or legal representative must also sign. The victim must also sign when there is a compensation clause, especially. Apart from plea agreements, we also do diversion. Diversion is an alternative to criminal prosecution. It is a means of resolving criminal cases without resort to full judicial proceedings. Diversion operates where a person has committed an offense and there is special reasons for that person to be given a second chance to avoid a criminal conviction. It's not a verdict of not guilty, but it is just a way of giving a suspect a chance to move forward without the burden of a criminal record. The legal framework, of course, is we have the regional conventions, which were mentioned earlier. I will not repeat them by the panelists. The rationale is that we have backlogs in court. We have issues of disproportionate sentencing, capital punishment being given to offenses where the suspect ought not to have been brought in court in the first place. And therefore, it also avoids a criminal record. It is said to be international best practice. And that is the rationale for diversion. It is guided by key principle such that the suspect must accept responsibility for his acts or omission. He must be ready to account to the victim. It is also underpinned by restitution, rehabilitation, and reintegration. We also try to be transparent. Diversion is it's in public interest. Who decides if a case is to be diverted? Prosecutors in the ODPP are responsible for running the diversion scheme. The DPP's prosecutorial powers must be exercised independently. A public prosecutor carries out prosecutorial functions as a minister of justice. The primary duty of a public prosecutor is to assist the court to arrive at a just decision and not merely to secure a conviction. And therefore, when we bring the cases to court, a conviction at all costs is not usually the goal. The victims can also request diversion. Judicial officer can request, the investigation officer, or even a child in contact with the law, if the child, especially when they are unrepresented. We have some options for diversion. They may include a simple apology to a full-scale therapeutic program and supervision. The public prosecutor has a discretion as to which option or combination of options is selected and may consult with program providers as required. Sometimes it may include a formal caution, a written apology, an oral apology, or even a commitment to keep the peace. In conclusion, we try to include diversion and plea bargaining in cases involving capital punishment, especially robbery with violence cases, where the death penalty is still a lawful way of sentencing, to try and address the gaps that are inherent in the criminal justice system. And therefore, when you see a prosecutor trying to make an application to have a case withdrawn, not just even in economic crime cases, we hope that the courts will allow our applications and not disallow them. And sometimes when we try to withdraw these cases, it's not because we are trying to be malicious. Diversion is also a way through which we can arrive at justice. It doesn't mean that the suspect is innocent. It's not a verdict of innocent, but we are just trying to address the issue through other alternatives to justice, alternative justice mechanisms. I would like to stop there. Thank you very much.
Thank you. Thank you very much, Mr. Mark Baraza. The agreement was that we do this session, then we have a plenary, a joint plenary for the other panelists. So I think it is now time we start the plenary, not only for the panelists sitting here, but for the previous ones as well. Justice Kizito.
Kizito J is my name. I have listened to the presenters, and I was almost getting worried. We speak about the death penalty, abortion, and someone talked about the Armed Forces Act, and I note that one of the sections is Section 18, which deals with cowardice. At this stage, where is the victim? Because we are talking about one side of the coin. I need to confess and state that I believe that the death penalty is a proper sentence that ought to be carried out. It's only our laziness that for some reason, we don't carry it out. But where is the victim in the debate? Lastly, I have listened with great pain the debate by Baraza from the ODPP. He scattered around the issue completely and went into diversion, into some policy. You are the ones who recommend these sentences. You didn't say anything about it. So I will ask this. If we have not been executing from 1987 or thereabouts, is it that we fear someone, or all these good things that happen, for example, the prisoner, what is the use if the victim is totally excluded? Thank you.
Thank you.
And just before I leave, and for those who are speaking about abortion, what is the other side of the coin? Is it that being anti-abortion and LGBTQ is a crime? Thank you.
Thank you. As we take that, we request the other panelists to move forward. Kindly, those who presented earlier. We have 2 seats, and we have others in front. Kindly. The next.
Thank you. Thank you. My name is Kerry. I want to talk to the issue of death penalty. And I want to start by stating my belief. My belief is that death penalty is not a deterrent of a sentence, but I also believe that the law provides for it. But how do we go about it? And before we go on, I ask how we go about it, I would like colleagues to watch a movie called Let Him Have It. Let Him Have It. I don't want to give any explanation on the same, but I just watch it. My take is that we have a very easy route, the one that the cabinet minister had taken, the act's way. Instead of doing going the constitutional way, which we know is a longer route, we can do the act way. I think that is where we should focus our attention to and ensure that we do away with the death penalty and we also define what is life imprisonment. Thank you.
Yeah, thank you very much. My name is Onyego.
Sorry,
John.
the panelists, kindly. This is now by order. Kindly come in front.
I have the mic. Okay, I think it's organized in the sitting arrangements.
Let's just allow the panelists to sit. Okay, you can continue, please, kindly.
Okay, I want to comment about the death penalty. Some of us who have been career magistrates over in the system, we have had robbery violence matters, now we are hearing murder. The manner and the mode of execution of these murder cases is terrible. People break into your house, they rape every female woman or every female child in that house, and then they start executing the head of the house. They literally kill in the presence of children, the wife, after raping them. And they are very happy, cooking chicken in that house in celebration of what they have done. I had an experience in Kiambu, and I think I had another one in Kilgoya. When such photos are presented before you by the scenes of crime, and the testimony given by the eyewitnesses, the children, the wife who watched how the head of their family was executed, people were happy raping them and cooking their house. I can't support the abolition of death penalty. I would rather say let the Muruatetu case apply so that in a very extreme circumstances, let the death penalty apply. And where the mitigating factors or circumstances give an imprisonment term. I support what my brother Kisito said. Where is the victim? Where is the family of the victim? Somebody has lost life in a cruel manner by thugs who even left the entire family traumatized. And we are now here seated campaigning for the release of such person. Thank you.
Thank you. As you ask, it will also help if you direct your question to a particular panelist. That would help them record. Thank you.
Thank you very much. Sorry. Thank you very much. Mine is directed to the team which was dealing with the issue of socioeconomic rights, especially the element of reproductive right to reproductive care under Article 43 of the Constitution, there are some elements which I did not hear the comment about impediment which hinder the implementation of that right, especially the issue of progressive realization of the rights at Article 43, which is anchored on provision of Article 21, sub-Article 2, which says that the government or the state supports to put policies and legal frameworks for the progressive realization of the socio-economic rights and how it affects. I would like to hear the comment about how it affects the implementation of socio-economic rights for reproductive health care. Then there was also other element, which is also captured by Article 20, sub-Article 5, where the courts and tribunals are limited in the interference of the policy on allocation of resources on socio-economic rights. Is also an impediment to the implementation and enforcement of socio-economic rights. Thank you.
Thank you. Do we take one more, or perhaps let's have the panel respond to that, starting with the panel on death penalty. Sorry.
Actually, one penalty that Amnesty is in favor on is the debt penalty. Those people who incurred odious debt on behalf of Kenyans should be penalized. But we're still working on that one. So let me, and I think this is really one of the big debates of our times, right? So let's just acknowledge we're in a moment when we're actually having important conversations. And I really thank the High Court team that basically put together this summit. I think there are a couple of things with regards to Justice Kizito, Justice Kiari, and also Justice Onyego in terms of focus. Let me start with the light response, which is, as we watch the movie Let Him Have It, I would also suggest, Justice Kiari, you watch a movie called Just Mercy. And this is a very powerful movie set in the United States about a lawyer who dedicated his life after one of his clients was executed. I think he was electrocuted or poisoned in a very terrible way. And I don't think we can fathom what it's like to essentially execute another human being. It's not a simple matter. In the Kenyan context, it's death by hanging. And if you look at the application of that, so the carrying through of the death penalty, just look at the people who were subjected to that, including our first Prime Minister, and that is Dedan Kimathi. It has been used against freedom fighters, it has been used against the poor, and yes, it has been used against hardened criminals. Right? So let me come to the second point that has been raised. It is not just laziness in terms of application of this tool. It is actually a sense of humanity that the last three presidents, including this one, have not executed somebody. The day that our president executes somebody in the manner in which the law still provides, I think we will see that the game has changed. President Kibaki, President Uhuru, President Ruto have not taken this stand. My concern is that we leave it to the whim of a president rather than a declaration of a set of national values for our country. And that is the point about abolishing the death penalty by an act of parliament. And I agree with the suggestion, let's go, I think it was Justice Kiari, let us go with the way forward, the act as the way forward. So I take that as instructions as Amnesty International. Thank you for your instruction. On the issue of victims, I sit here as somebody whose son, we've talked about this in public before, so I can tell you this story. 10 years ago, my son was blinded in 2 separate savage attacks by criminals. He lost one eye as a result of being hit with a chain, a very large chain, and it punctured his eyeball. 6 months later, just over a year later, we were together in a vehicle coming from Arusha, and we were attacked by 5 very violent people. I had enough stitches to have stitched a pair of jeans across my head. My son was actually caught with his second eye. He was blinded at the age of 27. I won't tell you that I have forgiven the attackers. What I will tell you is that my son realized that for him to have a vision for his life, now blind, he had to forgive his attackers. Because there was nothing, not even their execution in a hanging in committee maximum security, that would actually return his eyesight. He had lost that, it's gone. His path of redemption was to be sure that these people would be locked away, they would be taken through a corrective system, and they would come out knowing what they had done, and knowing that that is not what citizenship is. That is the truth. I'm telling you the story authentically. I could do another way. I could respond in a different way. But let me tell you from our own family experience that actually a life for a life does not produce forgiveness. It does not produce a society that respects life. It further demeans the life. So my request to you as judicial officers, as people who uphold justice, do not bring another execution, even in the context of the most vicious of executions that come before you. By all means, charge them with life imprisonment. By all means, toughen the correctional services so that they can do what they did with Ruth Kamande, so that less than 10 years after she was sentenced, you have a lawyer and you have somebody who respects the rule of law and somebody who will be before you in a court of law using the same law that you yourselves practice.
Thank you very much. Maybe just to add on to what Mr. Houghton has said, unlike him, I didn't come from a prison cell, but I came from a place which is very cold, almost minus something degrees. So transitioning from that place to this place, it can be quite difficult. But I really admire the way he's handling those issues. A question was asked why ODPP is taking these people to court. I just want to say that the Office of the Director of Public Prosecution is a state agency. We are neither abolitionists nor proponents of the death penalty. We just implement the law as it is. Our clients are the general people of the Republic of Kenya. But we are saying that there are cases which should not have been brought to court. And Article 159 of the Constitution of Kenya enjoins the judiciary to promote other alternative justice systems such as diversion, plea bargain, in fitting cases. And therefore, we do have a diversion policy. We do have diversion guidelines so that that young man of 19 years, 18 years, 17 years, who has just snatched a pen and threatened to use force, if you look at the penal code, that is robbery with violence, the ingredients have been established, and the sentence is death. But if you look at the circumstances of this young man who lives somewhere in Eastland, he comes from a broken family, he's not gotten any privilege to go to school, you do not want to criminalize that situation, like in the Gwanda case, which we were being told earlier, the Malawian case. Even our High Court has declared several penal provisions unconstitutional. And therefore, our penal provisions, most of them are very Eurocentric, and they are very colonial. This need that one is without question. We need to relook at our own penal provisions and try to bring them in line with Article 159. So what we are saying is that we are not just bringing all these cases in court and then saying we have to withdraw them again. But in fitting cases, such as that of a young man who has, you look at his background and applying the diversion and plea bargain guidelines, you feel like he should not have been in court in the first place. And I'm told we have around 11,000 such cases before the courts as we speak. It's a big problem, and we need to make use of these alternative justice systems to ensure that we do not end up with so many people on death row, because every day for them on death row, they are being re-traumatized again. Every time they see a prison warder come in, they think the prison warder is coming in for them. So we do not want to continue making the problem worse, but Article 159 enjoins us to use other alternative justice mechanisms, such as diversion, to try and fill the gaps, because as we wait for Parliament to enact legislation. I hope I have answered your question. Thank you.
Thank you. And allow me to just answer on the question of the victim perspective in the discourse on the death penalty. I agree. It's a very difficult conversation, and I think I presuppose that by saying that the public opinion is still divided on this. But in our conversation with certain coalitions and with certain organizations, there's an organization that stood out. It's called the Murder Families for Human Rights. I'll get the name right. And when they came before the convening that we had, and all of us were abolitionists, they talked about the victim's position in the whole discussion. And they said for them, when they lost their loved one, at first it was anger, an eye for an eye, a tooth for a tooth. Of course, they wanted the death penalty imposed. But with time, they realized even in the imposition of the death penalty, their loved one would not come back. Indeed, the punishment would be severe, but their loved one would not come back. And they asked whether the justice system could do more beyond the sentencing. Restorative justice, psychosocial support, counseling, therapy, because now it's a process of healing that is very different. And for us, we posit that even that person who is not sentenced to death penalty, but is sentenced to a life imprisonment, can work their way in order to honor the lives of that family that unfortunately they have disenfranchised by killing their loved one. They can apologize, they can make amends, but you see the irreversibility of the death penalty removes all that. So this person will be hanged or executed, and they will never make amends to that family. So that is another challenge that we see in this debate altogether, that the fact that the victims sometimes actually do not want the death penalty imposed, whereas some do, some don't. Thank you.
Thank you. So the next round of questions.
We have the LGBTI anti-abortion. I'll start with the easier question. It's not about what is on the other side of the coin. It's a question of what does the law say in the country you're in. And so you have to go back as a judicial officer and see what does the Kenyan law say around abortion? What are the limitations? What does it say? And how then do you apply that? It's not that one is advancing one right over another. It's a question because there are countries also where abortion is completely restricted and you cannot have it at all. And that is what the law of the day is, and that is what the people in the country have decided. However, science shows that in countries where abortion is completely restricted, you've got more issues of maternal mortality and backstreet abortion happening because people will still eventually access it. It's the same challenge we have with saying someone below the age of 18 should not be sexually active, but you see statistics telling you there's teenage pregnancy. So the question then becomes, how do you deal with a case that comes before you on this issue? Will you apply the law at hand, or will you apply your personal conviction at the case? On the issue of the LGBTI rights, look at it from the point of perspective. You're dealing with laws and international instruments that the country has ratified. The illegal thing in this country is covered under the Penal Code at Section 165, which says anyone who has sex against the order of nature with another person commits a crime. The order of nature has never been described, but that is a crime. So when someone who identifies as transgender, intersex, or gay is denied a housing, is denied a house, is denied access to health care, what then becomes the role of the judiciary interpreting, is this a human being who is entitled to the right to health? Do they become less human because they identify in a different practice that the actual identification is not criminalized, but it's the actual act? So it's a very tough balancing act for you as a judicial officer who's required to be impartial to see what is before me, what is the issue, and has a human right being violated. I speak here easily, but I know in reality, it is not an easy conviction to be able to have, depending on what exposure you've had in life about these particular issues. On the issue of Article 43 and the aspect of progressive realization, that is a very challenging area for the courts because it requires your litigants to be able to demonstrate that the government has not been making the required progress to attain the particular right. So if it's in the case of the right to health, if I sue the Kenyan government for not providing certain healthcare services, I need to be able to bring evidence before you as a court to say, this year they allocated this much and they've never allocated more, so they have been regressing on human rights, and as a court then you'll be able to make a decision. Now the reason why that clause was included was mostly because it was not easy to fully finance socioeconomic rights, but again, we've seen governments not moving in that direction. So that's the financial part, but there's the other part around policies and regulations, because the importance of the policy and regulations is what then leads to attaching a budget line to the things that need to happen. So you, judicial officers, have the ability to then compel the respective ministry, in cases especially where the Constitution gave clear timelines in which either Parliament or the executive was supposed to pass certain laws or policies. If anyone moves the court, that would be something reasonable for the court to consider and say, because of the absence of a mental health policy, because of the absence of a policy around this particular issue, then someone's right is being violated because the court is not being able, because the executive or Parliament is not playing the role that they need to be able to play. And then lastly, with regards to children, there have been arguments in various quarters that the Constitution has not been very clear because the right to health for children is under Article 53, but it's not called an Article 43 right. So does that mean the right to health for children is immediate and not progressive? That matter has yet to come before yourselves for decision, but it's something that is likely to come on board. So I think those are the questions that came up, and just to indicate to the moderator, my colleague Achieng is also online in case she's able to add on the aspect of progressive realization and the aspects of abortion and LGBTI. Thank you.
Okay, Achieng. Achieng can join us briefly. He has something to add.
My colleague Alan has said with regards to progressive realization and the question that was asked, more particularly to the substantive rights, I'd like to refer the room to a decision that came out of the Court of Appeal earlier this year, County Government of Bungoma versus Josephine Oundo Ongwen. It was Civil Appeal 61 of 2018. From around paragraphs 29, the court actually looked at what progressive realization means when it comes specifically to the right to reproductive health. And the court looked at what are the minimum core obligations that the state must meet. And this, I think, was the Honorable Judge took from the Economic, Social and Cultural Rights Committee's General Comment number 14, where they outlined that healthcare must be accessible, available, acceptable, and of good quality. And then there are minimum core obligations that are not subject to the progressive realization caveat. So care must be delivered without any discrimination, it must be dignified, it must be free from violence. But then what the committee says and what the court adopted, which is very interesting, is that part of this minimum core obligations is maternal health and child care cannot be subject to the notion of progressive realization. So when you look at it through that lens, then it guides on what the obligation of the state is to take quick and effective steps to ensure that all women in this country are able to access their reproductive health rights. Thank you so much.
Thank you. I can see it's going to 6, and I can read from our faces. Unless there is something burning. I think there is something burning this side.
I just wanted to respond to a question that was asked in the morning regarding institutionalization and community living. These are provided in the CRPD, there are quite a number of articles that talk about issues of supported decision-making, substituted decision-making, issues of intermediaries when it comes to persons with psychosocial and intellectual disabilities. And among the resources that we've provided is a small module that has been created by the World Health Organization regarding the specific articles that talk about mental health issues. And I think that's a very low-hanging fruit for us to engage with and probably get to understand the rationale behind these articles and why the CRPD came up with them. Thank you.
Thank you.
Just to respond on the issue of the death penalty, because throughout all the conversations today, which have been amazing, by the way, we all forget that issues of SRHR, experimentation on death penalty, all of this was carried first against persons with disabilities. That's why we all perfected the art of the death penalty. The UNCRPD issued a communication against Australia, very good, strong communication against Australia in the 2022 review, saying that persons with particularly intellectual disabilities cannot be subjected. Intellectual disabilities, persons with schizophrenia, psychosocial disabilities, persons affected by alcohol and drug abuse cannot be subjected to the death penalty. For one reason, when you look at the crimes that they committed, we'll pick on the Australian case, specifically that involved a person with severe low intellect. If your intellectual level is below 75, your IQ, you cannot be, it goes to the tenets of criminal law. Intention. Do you have the mens rea? Do you have the act? And when you look at persons with disabilities, half the time, there is no intention. It's usually self-defense or learned behavior, or they're being used by other agencies to actually get this done. The question of abortion, again, this was practiced during, with the Nazis, figuring out how to, the abortion was perfected using women and girls with disabilities, because they were trying to figure out a way to sterilize people that will actually work. So when we look at these issues from a human rights perspective, what have we learned from the disabled community? And how can we then use this to change the system? Because it's all our attitude and our legal barriers that we put there that we need to change.
Thank you. Thank you very much. Can we give them one round of applause? Heavy one. I think that's all we have for the panelists now. So kindly, you may resume your seats as we get the next directions for the day. Karibu.
With very little ado, let's give a round of applause to Judge Ado and Justice Wakiaga and Justice Ougo. Ladies and gentlemen, this has been a very long day. But as I sat there listening to the presentations from the panelists, it just occurred to me how great a mind these judges are. You listen to the panelists whose business it is to focus. Yeah, and the judges make judgments on these issues that is not their daily business. And they're supposed to understand it as well as the academics in the area. And somehow they get it right. I think that is something that we need to acknowledge. You didn't go to law school by accident. You have just big minds. You move from death penalty to disability to abortion, with all their intricacies. Actually, it's amazing just listening to those things. Then tomorrow you move to commercial division. Insolvency. I mean, then the next day you are, come on. I think you've earned your cocktail. So there is a cocktail this evening. The PJ is very gracious. Thank you, PJ. We shall be reasonably drunk at your cost. So tea and cocktail is served by the poolside. Please, by the poolside. Don't jump into the pool. Tomorrow we start at, Justice Mulwa is very tired. 9 o'clock? PJ, the college has said, either we start late and leave late, or start early and leave early. A or B? 9. Okay, 9 it is. So let's be here a few minutes to 9. So 9 sharp we start so that we also don't take too long in the day. Otherwise, thank you very much, the speakers for today. Asanteni sana. Enjoy your cocktail. The cocktail is yours, so please don't go without partaking. PJ, anything you need to say? The Registrar of the High Court, Clara, any announcements that you need to make? Clara? I don't, there is none. Okay, thank you very much. Prayer. Church elder is the PJ, he's my church elder. I also go to